Good afternoon, everyone. Thank you for battling the southbound traffic to get here. There may be some stragglers who join us, so just please bear with them as they come in. I guess we're back in full swing concerning the city traffic. So thank you again for being here in spite of that. My name is Mike Cicero. I'm an IP attorney with the law firm of Taylor English Duma in Atlanta. Since 2020, I have served as the chair of the Trade Secret Committee of the Georgia Bar IP section, and the preceding 3 years, I served as the committee vice chair. As the committee chair, I appreciate all of you joining us today for the seminar titled The Why and How of Trade Secret Management, why it is critically important, and how to actually accomplish it. And I would especially like to thank all of our distinguished panelists, James Pooley, who's going to be presenting remotely, and our two live panelists, Chantel Hibbert Clark and Chris Buntel, for all of the time that they spent in preparing the presentations that you're going to hear from them today. I would also like to thank Lane Sosby, Mary Jo Sullivan, and everybody at the Georgia Bar who provided critical assistance that we needed to put together today's program. And just as a couple of administrative notes, if you have not silenced your cell phone, please do so at this time. Also, those of you who have not gotten your parking ticket validated, you can get it validated at the desk right by the door where you exit the parking garage. And also, for those of you who didn't already know this, the hallway that you used to come down here, there was where the restrooms are located. The men's restroom is the door just before you get to the exit door for the parking deck, and then the ladies' restroom is before that one on the right-hand side. And today's seminar covers just one of the many trade secret issues of interest. And we encourage anybody who's interested to join our trade secret committee. Feel free to speak to either Neil Weinrich or myself afterwards, or feel free to email us. I'm at mcicero@taylorenglish.com. And Neil is at neilweinrich@bfv.com. Also, we had a question earlier about the Wi-Fi password, and it is posted at the podium here, but I'll go ahead and read the network. The network is GA_1, and the password is State Bar Law !42023. All right, now, speaking of Neil Weinrich, I would also like to thank him for all of his work that he did in working with our panelists to organize and put together the presentations of one cohesive PowerPoint deck that's going to be used for today's presentation. And by way of introduction, Neil knows non-competes and trade secrets issues inside and out. As a shareholder at Berman Fink Van Horn, Neil, who's going to be serving as our moderator today, counsels clients in all industries on matters involving restrictive covenants, trade secrets, and other competition-related issues. He represents employers and employees, plaintiffs and defendants in disputes involving non-competes, customer non-solicits, non-recruits, and non-disclosure covenants. He represents clients in non-compete disputes throughout Georgia and in jurisdictions across the country. He also litigates competition-related cases involving various other claims, including but not limited to tortious interference claims and claims under the Georgia Computer Systems Protection Act, the Computer Fraud and Abuse Act, and/or violations of the Stored Communications Act. Recognized by Super Lawyers since 2012 and Best Lawyers since 2021, Neil writes and speaks frequently on issues that arise in competition-related cases. He is the co-founder of and regular contributor to the Non-Compete and Trade Secrets blog. Neil is a past chair of the Labor and Employment Committee of the Atlanta Bar Association, in addition to serving as vice chair of our committee. He also served on the drafting committee on covenants not to compete for the Uniform Law Commission, and served as the co-chair of the Ethics and Professionalism Committee of the Young Lawyers Division of the State Bar of Georgia. A graduate of Emory University Law School, Neil received his Bachelor of Arts from Tulane University. He is an avid Atlanta Falcons fan and enjoys running road races, playing tennis, golfing, traveling, and spending time with his wife and two sons and their family dog, Sutton. And with that, I'll hand it off to our moderator, Neil.
Thanks, Mike. I appreciate the introduction. I have the pleasure of introducing our excellent panelists for this program. Our first panelist that I'm going to introduce is Jim Pooley, who's joining us remotely. We're very, very lucky to have Jim participating in this program. Jim is truly a not only national but international, one of the most recognized figures when it comes to trade secret law. Truly kind of a godfather, if you will, of trade secret law. Jim is a Silicon Valley lawyer representing clients in trade secret and technology-related commercial disputes. He advises companies on trade secret strategy and management. He also serves as a special master, expert witness, and arbitrator. And I can tell you that me and my partners, when we have a tough and thorny trade secret question, or we need a recommendation for an expert or something trade secret related in one of our cases, Jim's at the top of the list of people we reach out to find out what he knows and who he knows. Jim's an author or co-author of several major works in the IP field, including his treatise Trade Secrets, which we have here. This is Jim's book, if it gives you an idea of what he knows and where he stands when it comes to trade secret law. His most recent book is Secrets Managing Information Assets in the Age of Cyber Espionage. Jim testified and gave advice to the Senate Judiciary Committee when it was considering the 2016 Defend Trade Secrets Act, and one senator later called his participation instrumental in achieving passage of this landmark legislation that's had a very significant impact on I know my practice and the others in here who have a substantial trade secret law practice. In 2014, Jim completed a 5-year term as Deputy Director General at the World Intellectual Property Organization in Geneva. He's a past president of the American Intellectual Property Law Association and a former chairman of the National Inventors Hall of Fame. In 2016, Jim was inducted into the IP Hall of Fame for his contributions to IP law and practice. So we are very lucky to have Jim here with us today. To my immediate left is Chantel Hebert-Clark, who is a friend and classmate from my Emory Law School days that I'm excited to have her on the panel with Jim and Chris. Chantel is the managing attorney of employment at Van der Lande Industries, which is a Netherlands-based company that has its U.S. headquarters here in Marietta, Georgia. Chantel is an experienced employment attorney who has spent more than a decade vigorously defending employment litigation and partnering with in-house counsel and human resources professionals to prevent, correct, and advise on day-to-day employment issues. Now, as an in-house attorney, Chantel advises her internal clients on sophisticated and nuanced employment law issues and provides counsel regarding all aspects of the employment relationship, particularly with regard to difficult employees or challenging workplace situations. Outside of her law practice, Chantel is heavily engaged in her community. She's active with the Gate City Bar Association, serving as president, foundation chair, and she currently sits on the past president's council. In 2019, she was elected to the board of the West Side Future Fund, a nonprofit formed by Atlanta's public, private, and philanthropic partners who are committed to stabilizing the historic West Side. She's received numerous recognitions and awards, including the 2023 Atlanta Business Chronicles Corporate Council Rising Star Award, the 2021 40 Under 40 Award, the 2019 40 Under 40 National Bar Association Nation's Best Advocates, outstanding class of 2016, the Lawyer of Color Hot List for the 2014 Southern Region. As you can tell, her accolades are too many to list, so I could go on, but I could stop there. She's a member of the Church of Christ at Boulder Crest and resides in Atlanta with her husband, Jason, and her 7-month-old son, Jace. So we're pleased to have Chantel here with us today. Our final panelist is Chris Buntel. Chris is here in person as well. Chris is a U.S. intellectual property attorney with over 20 years experience connecting innovation and intellectual property law. He is a co-founder and the chief intellectual property officer of Tangibly. Chris is passionate about trade secrets, the next best big thing in intellectual property evolution. While other forms of intellectual property have been well supported for years, people are just now realizing, as you'll hear today, the huge need for trade secret management tools in education. He is also the founder of Inflection Point Technologies, a Singapore-based IP consulting firm helping clients in Southeast Asia and beyond develop and protect new technologies. Previously, he was head of Zenova's Singapore office and director of Intellectual Ventures Asia, expanding their outsourced innovation network across Southeast Asia and building a large patent portfolio across chemistry, materials, agriculture, and food and beverage sectors. You'll hear more about Tangibly, but in recent news from only a couple of weeks ago, Tangibly announced that it completed its seed investment round of $6.5 million. It's using the proceeds to develop an AI-powered patent X-ray tool, which when implemented will allow in-house legal teams and outside counsel to rapidly identify potential trade secrets associated with issued and published patents. So those are our three panelists today. I'm going to turn it over to them. We do have a period at the end reserved for questions and answers. So we will have some time carved out for that. If you could save your questions till the end, we look forward to having the panelists answer them. And I'm going to turn it over to Jim to kick off the presentation.
Great. Thank you, Neil. Thank you, Mike. And thank you, everyone, for participating here. I wish I could be there in person with you, the traffic notwithstanding. But I think what we're talking about today starts with the observation made in the announcement that there has been some recent case law on the element of reasonable efforts. One of the things that you have to prove in order to make your trade secret case is that you have engaged in reasonable measures or reasonable efforts to protect the information you're claiming as a trade secret. Now, there hasn't been any blockbuster case on that in recent times, but I can tell you that over the last several decades, certainly since the early days of the Uniform Act, courts' attitudes towards reasonable efforts have shifted very dramatically, actually, from something that doesn't really matter and can be assumed to exist to something that judges are looking at very skeptically, particularly in federal court. And there have been cases that have been dismissed at early stage on just that issue alone. So that's one reason we need to be paying attention to this, but it's also because our clients are managing trade secrets as an asset class day to day, and we need to help them as they deal with these issues and try to understand what it is that they need to do. So the presentation today, I should say, at least my part of it, was designed to be presented to a mix of lawyers and non-lawyers. For us, I think you'll see it tries to confront the fact that we tend to see this area of the law, through our own legal lens, and it's not always exactly what the clients see or need to see. For the clients, we have to help them recognize that this is a challenging area, even though they might not recognize it, because trade secret loss, including theft, is a silent killer. You really don't know what's happening out there as readily as you might, for example, with other kinds of violations of intellectual property rights. So it's something that takes active management, and that's what we're going to be talking about today. It's not just, by the way, about avoiding loss of these assets or damage to them. It's also about preserving the opportunity to increase enterprise value, because that, at the end of the day, is what these assets are all about. Two important basics to keep in mind, and we'll probably repeat this later. First, there is no one-size-fits-all here. The design of a system appropriate to any company depends on the risk environment for that company. And so you can't just go down a list of things, tick off the boxes and say, well, we've done it. It depends on what it is that you're trying to protect and what sort of risks exist in your particular business model. And the other message is, and this is really important, it's not as hard as you think. So let's get started. We can go to the next slide. And the next slide after that. Yeah, we're here. Let's remind ourselves that we're talking about something where the world has shifted during the lifetimes of most of us around here from an asset, a world of assets that are primarily hard and tangible, to a world of assets that are mostly about data. And so this is something we're reminded about every day. Next slide. While we're changing and shifting into this data-driven economy, we have to recognize that the way that we deal with data makes that asset basically quite vulnerable, because we store it and we communicate it digitally, for one, and for another, we're expected to share it. In fact, that's the only way we can monetize and commercialize this asset is by getting out there and sharing it. We realize that we can't do it all alone, and so we have to team up with others to create open innovation environments. All this sharing means that it's a challenge for us to maintain confidence, confidentiality with these kinds of assets. Next slide, please. We're dealing here with the oldest form of intellectual property. I show the silkworms here because the Chinese protected their monopoly on silk and silk weaving for centuries through secrecy. Next slide. But we tend to look, we intellectual property lawyers tend to look at this area through our own particular lens. And especially if we've been involved as counsel in, on the patent side or other areas of the registered rights, it can be a problem, because looking at trade secrets, it seems so mysterious. Less so now, perhaps, because we have a federal law, but traditionally, trade secrets was a subject that was defined by state common law. And it wasn't ever very clear what was the doctrinal foundation of this area of the law. And so it just seemed really mysterious and weird. You had to go into state court to address these issues. And so a lot of intellectual property lawyers tended to ignore them, and they had good excuse for doing that, because we had, before the AIA, we had the issue of best mode and validating patents. And so the approach generally was, well, let's put everything related to the claimed invention into the application so we don't have that kind of problem. And now that we're over that, and we also have prior inventor rights. And so the focus is really clearly back on trade secrets where it ought to be. Now, let's look at how clients, next slide, how clients view these kinds of assets very differently than we do. Clients see trade secrets in the same way that they look at other assets and liabilities, because they have, in their operations, they have to deal with them in ways that create liabilities. And so for our clients, this is the kind of thing that matters to them. This is the lens through which they see these issues, and we need to keep that in mind. The next slide, please. It's obviously becoming more important, in part because we see the results in cases where there have been disputes over trade secrets and the valuation that's been put on these kinds of assets. So this is an issue in part on risk avoidance, but it also is a measure of the very expansive coverage of trade secrets, which can be valued in the millions or even billions of dollars. Next slide, please. So now we're going to go quickly through a process of tutoring our clients on what the basic law is on trade secrets. Next slide. And distinguishing them and relating them to the other forms of intellectual property is often helpful because they will have had some familiarity with registered rights. So this will be useful to them. Next slide, please. And again, what we're trying to do when we talk to our clients about this is to emphasize the breadth of coverage of trade secrets. Unlike patents, which are defined by particular claimed invention, this is just about information that may be of some value. It doesn't even have to be in use currently in the business. It can be just something that might help in the future. And so impress on them the fact that these assets are ubiquitous in their business, and there's a lot that they may be missing. Okay, next slide. And here are examples that you can use to talk about them with clients in ways that they can relate to specific areas of their business, as opposed to a purely legal category. Next slide, please. So now let's get into the meat of this, managing trade secrets. Next slide. Critically, we need to keep in mind as we convince our clients that this is an important area for them to look at, and they should be listening to us as we try to help them with their management. We should define what the objectives are. And here I've listed the ones that most companies consider. First of all, preventing loss. That's the outbound risk. We want to keep control over the information that gives us a competitive advantage. And secondly, there's an inbound risk, and that's the risk of contamination that usually shows up either in hiring high-level people from a competitor, or perhaps in looking at potential acquisitions or licenses where the company gets exposed to confidential information that belongs to others. And we need to manage and regulate all of that. There are issues around emerging standards from various government agencies that create expectations in how the company and its board will treat the company's assets, including intangible assets. And finally, of course, we want to be able to demonstrate, if we have to go into court, that the company has engaged in reasonable measures or reasonable steps to protect the information that's being claimed as a trade secret. So having a program that you can point to and say, this is how we address this area of risk will be very helpful. Next slide, please. So there are basically three factors to take into account here, and there's case law to back this up. And look, this is not rocket science. What we do in trade secret risk management is the same kind of process that businesses engage in with respect to all other kinds of risk management that they do day to day, depending on their business model and the industry that they're in. This is just another application of those classical principles about identifying the asset that you're trying to protect or the position that you're trying to protect, and identifying the risks to it, the risks that exist that might prevent you from commercializing it in some way, and then identifying the available measures to either reduce or transfer or eliminate those risks in a way that works within your given environment. And of course, when we're talking about information security, we have to keep in mind on that last point of mitigation measures that every approach that we use to enhance information security comes at a cost. of inconvenience that creates some level of resistance. We have to anticipate this. We have to make sure that the things that we introduce or that our client introduces into the corporate operational environment are acceptable to the people who are there. It does you no good to have a a classification system for the sensitivity of your data, for example, if it has 7 or 8 categories that no one can clearly understand. And so as a result, no one pays attention to it, and you have a lot of information out there circulating around the company, or worse, outside the company, without any designation at all. And that's just one example, but you can apply that principle across the board when it comes to the design of this kind of program. All right, next slide. We're going to look at the 3 main areas of risk that are very typical for most companies. Certainly the companies that I've worked with, universally, these 3 come up. And the first area is people. And despite all the technology that we deal with these days and the wonderful tools that we have to enhance information security, protect us from hackers and all the rest of it, ultimately, it's people that control these systems and that pass information around, that make the greatest number of mistakes in how they're handling information. And therefore, people in almost any organization are the #1 vector for information loss. That's true across the board. A number of studies have confirmed this. And so this is the place where almost all businesses should start. And we look at 3 primary dimensions of the relationship with employees, at the beginning, and at the middle, and at the end, to help us think about what our approaches should be to reducing risk. Obviously, in the onboarding part, when we're recruiting, we're mainly trying to avoid contamination, but there's also a very important opportunity to make sure that everyone has the same understanding about what the company's approach to security management actually is. And that training then, and other forms of communication, goes on for the duration of the employee's presence at the company, and it has to be meaningful. I can tell you that in cases where I've testified negatively about some companies' approach to information management, this area of training has been the weakest link in most of those systems. It's a lot of companies just use things that are off the shelf and do not succeed in getting across to the employees exactly what is the kind of information that they need to be protecting and what their role is in doing it. Even though training, as it turns out, is the most economical way to protect your information. It doesn't take a lot of investment to have a lot of impact. And then, on the way out, depending on how it happens and where people are going, many other factors, there is a heightened risk, a particular kind of risk at the time of separation. And so we need to pay close attention to that, ensure that we have taken advantage of whatever information is available to us about where this person is going and what they're going to be doing, so that we can view that particular situation as an instance of risk management itself and do what we can to reduce those risks, and in cases of very high exposure to risk, track what's going on and create appropriate responses. All right, next slide, please. The second general area of risk that's fairly common in most companies is the risk of not handling this kind of issue in a normalized way through a process that is well thought out and strategically designed. So the approach for most companies should be not to look on the internet for an example of somebody else's program, not to go ask somebody else what they've been doing other than to help inform the process. But they need to start with, at a strategic level, with creating policies that define what their general approach is to information risk management, and then institute controls throughout the process, controls on anyone who might touch the information in some way. Internal people, because of the insider threat that I mentioned earlier, and external relationships, of which there are many, some regular ones with customers and vendors, and some one-offs with those opportunities for M&A transactions, as an example. And so all of these controls need to be well thought out and designed in a way that fits with the company's culture and general business model. And then finally, this is an aspect of controls that bears particular attention because of the way that we now deal with information, that certainly contrasts with how things were when I started 50 years ago. Back then, there were no networks, there was no internet, there were no cell phones. And so all that a company needed to do was watch the photocopier and watch who went in and out the front door. But these days, every employee holds in their pocket a massively powerful computer and communications device that links into the company's networks and allows them to engage in all sorts of transactions and have access to information as permitted by the company. And these same people, of course, go home with that device at night, and they use it for other things, and they're on social media where they've been trained for a number of years that sharing is a very good thing. And so we have a risk environment there that bears particular attention, and we have a number of tools that allow companies to reach out and maintain control over what kind of information goes in or out of those devices. Okay, next slide. Finally, I've chosen several areas of general management that typically require attention when you're designing this sort of program, and certainly when you're executing it. And number one is what I've come to conclude is the single biggest, most likely source of commercial business-to-business trade secret disputes, and that's a failure of NDA management. Because we treat this contract not as a contract, but as a form, and maybe we can use yours, maybe we'll use mine, it doesn't really matter. But there are a lot of very consequential provisions in NDAs, not just in the language itself, but in the implications for responsibilities that are taken on by the parties to the NDA to manage information that belongs to somebody else, to identify information that's newly discovered and who has responsibility for it, and to follow up to make sure that it's protected, to make sure that it is adequately monetized and so forth. So that's an area, sort of, if you're looking for low-hanging fruit, that's one place where a lot of companies need your help. A second area we've heard a lot about in recent years, supply chain issues that were impacted because of COVID, and the disruption that's happened there has bubbled up to the top, a lot of very challenging issues when it comes to trying to control our information as we have to share it throughout the supply chain. And here we have to keep in mind, it may be hard to appreciate, but the US law and procedures on enforcement of trade secret rights is the gold standard in the world. And frankly, no one else comes close to matching it. And perhaps the UK, Canada, and Australia, the Commonwealth countries that have that tradition may approach it. But in most of the rest of the world, civil law jurisdictions, it's very hard to figure out what has happened to your data when there's been a problem, or even if there's a problem at all. And therefore, we have to pay a lot more attention to the provisions that are in contracts and how they get enforced. Non-compete agreements, which we're going to talk about briefly, I think, are an example of that. They are accepted and enforced regularly in China, as are penalty clauses. So we need to think about that to the extent that our clients have international operations. And then finally, as a dimension of business management, we need to ensure that our clients are thinking about avoiding litigation because of the enormous disruption that it brings about. And if you're in a dispute, as we've all witnessed before, trade secrets are more like divorces in their emotional content than any other kind of commercial dispute. And so they become very difficult to manage. And if clients can anticipate this, they probably can do a better job at avoiding them. All right, last slide here, please. So here's the good news, right? Creating a plan is not as hard as it might seem. We hear a lot of terminology that's borrowed from the financial sector about inventory and audit, right? We have to engage in an intellectual property audit, a trade secret audit, and that creates certain reactions in business people. And inventory is even worse because it conjures the image of the neighborhood hardware store that has to shut down for 3 days while they count all the nuts and bolts. And that's not what is required for reasonable measures. It's not what's required in order to achieve the objectives of a basic information security plan. What you need to know is just what are the kinds of things that we most need to protect. Ask the managers who are in charge of the business. They know that. And then have a conversation among all those managers about what can we do to reduce the risk, and make sure that you're focused on the risk and not just creating some set of rules that somebody has said will increase the security of your information. And then secondly, I've found over the years that having central authority, you have to have one champion for this kind of enterprise within the company, although responsibility for execution has to be distributed to people who are in touch with the business day to day and can provide feedback on what's working and what isn't. And speaking of that, a central part of any one of these programs has to be a consistent way to review how it's working, because nobody in business lives in a static risk environment. Things are always changing. The nature of the assets are changing. And so this process has to be adjusted as well. So I will stop there and turn it over to the next speaker. Thanks.
Good afternoon, everyone. I'm usually pretty loud, but I've been hoarse for the last couple of weeks, so I'm going to use this mic. Thank you all for being here, and I want to say thank you to both Mike and Neil for the invitation. I practiced at Taylor English for 12 years before going in-house a little under 2 years ago with Mike. And as Neil mentioned, we've been friends since Emory Law. So good to see both of these gentlemen and to be here with you today. I am not an IP expert or an IP attorney. I'm an employment lawyer. And as I mentioned, I went in-house a little under 2 years ago at a company called Van der Lande Industries. It is pronounced Van der Lande. It is a Netherlands-based company, and you've never heard of us. But if you've traveled this summer, we're in, I believe, 15 of the top 20 airports in the world. We create baggage handling systems. And so the technology that gets your bag from check-in to the airport, to the airplane and back is what Van der Lande creates. And we also create similar technology for warehouses. So think Amazon warehouses, think Walmart warehouses, think Vans shoes if you wear those. And so we are an automation technology company. I am the first employment lawyer for the company. And so raise your hand if you are in-house. Is anybody in-house? Okay, great. You guys might be way better versed at this than me. But like I said, when I joined Van der Lande, I was the first employment lawyer. The company knew that it needed to have an IP agreement. This is something that they had already thought about, had already had outside counsel to draft one, but it had not been rolled out yet. And so, of course, I joined the company. I inherited this IP agreement, and I was tasked with rolling it out. And so, again, drafting the agreement was already done. But before I would roll it out, of course, I reviewed what was drafted. I compared it. We're a small industry, right? There are only a handful of competitors in the automation technology industry for warehouses and airports. And so we recycle employees, we exchange employees, which goes to the point about why another reason to want to protect your information as well as keep competitors' information out, right? We don't want lawsuits. So reviewed the agreement, looked at some competitors' agreements, looked at some sample agreements. I love Practical Law. That's a plug, if free plug, because they don't pay me, but it's a great resource for me. So looked at some IP agreements on Practical Law, just to make sure that what we were rolling out was in line, was tailored to our company, and was going to fit industry standard, right? So then determining the recipients. This was a real source of negotiation. So for our employee base in the United States, we have probably about 1,200 employees. I would say about half of those are engineers. The other half consists of your corporate employees, your sales engineers. We have service teams that are at airports that actually maintain some of the baggage handling systems. DFW, LAX are two of our bigger contracts in the US. And then we also have, obviously you have marketing teams, you have HR, et cetera. So who's gonna get the IP agreement? There was a lot of negotiation, but it was decided that it would go out to the people who we felt had the most intellectual property information, which of course would be all of our engineers. And then determining the motivation, right? Because Van der Lande has been around. It was initially a family-owned company. It's been around for more than 50 years. We've been in the United States for, I believe, close to 30 years. So we have employees who've literally been with Van der Lande in North America for 20 plus years. What is going to be the motivation for them to sign the agreement today, as opposed to 20 years ago? And how do we get them to understand the importance of signing that agreement when they've been doing this work for 20 years? And then, of course, looking at the laws, right? We operate in at least 10 states. And so looking at what is consideration? Is continued employment sufficient consideration where all our employees are? These are all the considerations that we had to look at before we rolled it out. Next slide. Oh, I have it now. Let's see if it works. Ooh, ooh. All right, I'm not a technology person, people. So then determining the timeline. So again, we run on our fiscal year is actually April 1st through March 31st or March 30th, 31st. Work with me. And so, but we decided just the timing of it that we were gonna roll this out in the summer of last year. So I'm a new employment lawyer. Nobody's ever rolled out an IP agreement. It's the summer and people are very suspicious about why. But like I said, the company already had this IP agreement. This is already on my GC's agenda to get done. And so the timing wasn't as strategic as it could have been. This was just a good time to roll it out last summer. But then you have to determine how long is it going to take? Oh, let me back up. Did I mention that we're a technology company that doesn't always use technology in-house the best? And so we are a Netherlands-based company. A lot of our technology is still run out of the Netherlands, right? So we have Workday, which is a human resources management tool. And I said, we are not going to hand out paper copies to people, right? We are going to do this electronically. I will tell you that it was a process just making sure that we had the internal controls in the US to be able to roll this IP agreement out to the specific employees, which was about 400 employees, that we wanted to roll it out to in the United States.
I'm sorry to interrupt. I'm a little unclear when you say an IP agreement. Is it just an NDA or a non-compete, or what exactly are you getting from the employee?
Absolutely. So the actual title, which I'm shorthanding it IP agreement, is Employee Invention Assignment and Confidentiality Agreement. So it did not have a non-compete, it did not have a non-solicit, which was part of our rollout explaining that, because as I mentioned, we're in a small industry and we have a competitor that has an IP agreement that's called an IP agreement that has a non-soliciting. And that, because we had employees that had come over from that company, because we had employees that were just familiar with that IP agreement, there were a lot of questions and people thinking that we were trying to like slip one in on them for a non-compete or non-solicit. But it did not have a non-compete. It did not have a non-solicit. It was basically asking for a disclosure of inventions. It had an invention assignment. Obviously, it had confidentiality. And I'm going to tell you guys two of the clauses in here that gave me the most heartache. The assignment of other rights, moral rights. Does anybody, I mean, you guys, I'm sure know what moral rights are. Explain, I'm not an IP attorney. Explaining what moral rights were to a bunch of engineers was a whole process, right? So getting your talking points together. And so for the rollout, we did, document socialization. So again, this was my first rollout. I scheduled a session with managers, right? I'm going to talk to all the managers who their employees are going to be getting this agreement. Everything is on Teams now. Had a team session with the managers, said, hey, this is the agreement we're rolling out. Here's a high-level overview. I also prepared basically an IP agreement explain document that I would send to them in advance. You have to have a PowerPoint because everything is PowerPoint in corporate America. So a PowerPoint for this presentation. And then I tell them, hey, go have team meetings with your employees and tell them, and we also had an IP training that we use Skillsoft. And so there was an IP training. So in advance, about a month before the IP agreement would be rolled out, we rolled out an IP training just to all of our employees, just kind of as a reminder. Here's what IP is, here's, with patent, trade secrets, et cetera. Here's what we want you to do. So we rolled out that training as kind of a soft, introduction to this IP agreement that would be coming. So I did the session with the managers, sent them the IP agreement explained, sent them a copy of the IP agreement and said, hey, start having meetings, at your morning meeting, whatever your weekly team meetings are, tell them that this is coming. What did they do? Came back to me. My team has questions. My team has questions. So then I had to set up a series of Q&A sessions. I will tell you that now, having done this, I would have on the front end just scheduled 2 Q&A sessions and said, be there if you can. We're going to record this and you can watch the recording afterwards if you miss it. I did not do that because I had not done this before. So I let all of the managers schedule their own Q&A sessions, which means that I had about 6 to 8 Q&A sessions with a lot of hostile engineers asking me a lot of questions about this IP agreement. But we got through it. We got through it. As Neil mentioned, I have a 7-month-old, so I was pregnant at the time, maybe a little irritable, but we got through it. And there were a lot of questions because I will tell you that what I did not know, which I learned, is that engineers do a lot of things on the side. And so what they were really concerned about is having to disclose what they were working on the side to Vanderlande. And the whole purpose of, I had to keep emphasizing that the purpose to disclose it to us is so that it is excluded. We want you to let us know what you're working on, not because we're trying to steal your great idea, right? If you're inventing the next Facebook, we're not trying to steal the next or invent the next Facebook. Like, that's not our business. But if you are working on something that is closely aligned to what we do, there needs to be another determination to let you know if we feel that we have a claim to that invention, right? Or whatever you're working on. So this was a whole series of, like I said, Q&A questions. They had a lot of questions around the disclosure. And then, of course, the assignment. And so then, again, engineers, smart people, Google rules the world. I literally had to explain to them that even if they did not sign the agreement, the work that they did was still belonged to Vanderlande, right? It would just be a harder road to litigate if it came to that. I had an engineer, as soon as we got off of Q&A, literally within 10 minutes, I told them that there were state laws that protected this information as well, who looked up the Georgia Trade Secrets Act and sent me a link to it. Like, yes, sir, I know that it exists. I just told you on this call that it exists. But these are the types of conversations that you're going to have with your internal employee base. And then, of course, they want to know, well, why isn't it being rolled out to everybody? Why are we being targeted? So again, that was above me now. That was a management decision to roll it out only to our engineers and very closely related employees. But that is not foreclosed from being rolled out to everyone, right? So what I explained to them is, listen, this is where we're starting, but not necessarily the end point. We might eventually roll it out to all employees. And, some people are like, well, why does the secretary need an IP agreement? Why does the security need an IP agreement? I'd rather be overprotected than underprotected. And you don't know what people have access to, right? People share information, they share documents. Some people move from one department to another department. They don't get removed from the other department's listservs or the other department's internal access. And so I would have preferred to roll it out to all employees at one time. But again, that was not my decision. But those are the kind of conversations you have to have. The moral rights, like I said, trying to explain to them what moral rights were. And another one was the name and likeness rights, right? So name and likeness, why is my name and likeness being waived to Vanderlande? And then I had to explain, we're not trying to steal your name. We're not trying to steal your rights to your autobiography. If you're part of a presentation or part of a team that has done work for Vanderlande, that has created some software, some technology for Vanderlande, we don't want to have to scrub your name in your face from every material, all of our materials going forward. So these were just some of the things that I had to deal with, that I encountered when rolling out the agreement. Then document collection, again, getting it rolled out through Workday, making sure that we had the exact employees, because we weren't sending it out to all U.S. employees. Now we had U.S. employees that are now in Canada, making sure that they knew that this agreement was not, because we have a lot of employees that travel across the globe, right? We might have a U.S. employee that goes to the Netherlands for 6 months, that does an assignment in Canada for 2 years, et cetera. So making sure that we were only sending the agreement to the right employees, and then making sure that it would be automated, right? After this rollout. So we did a 2-week period for them to review and sign the agreement after the Q&A sessions ended. And then after the 2-week period, of course, we had managers and HR follow-up, because of course we did not have 100% compliance in those 2 weeks. And then worked with our talent acquisition team to ensure that anybody hired into these specific groups going forward would receive the IP agreement at onboarding. So that's the automate part. And then enforcement, right? What is going to happen if you decide not to sign the agreement? Because of course, we had a 20-year employee who said, hey, I'm not gonna go back and disclose everything I've worked on for the last 20 years. We did not actually want you to go back and disclose everything that you've worked on for the last 20 years. But B just, drew a line in the sand and said, I'm just not going to sign it. So what are you going to do to that employee, right? Are you going to not let them work? This employee has critical knowledge base there. He's a leader on a team. What are you going to do? So we had to make the decision, can they not get a raise? Can they not get a bonus? Are they not eligible for promotion, right? And these are management decisions, right? I, as the employment lawyer rolling it out, can make recommendations, but I don't get to make that decision. The decision was made that you are not eligible for promotion if you do not sign this agreement. So we did not withhold any bonuses. We did not withhold any pay, but you're not eligible for promotion if you do not sign this agreement. So these were, like I said, some of the issues that I dealt with. And I tried to make a note. Oh, and just Jim reminded me just on onboarding, I'll tell you two things. We actually had litigation that I inherited when I joined, and it was restrictive covenants litigation, basically a competitor saying that we were hiring their employees and forcing their employees to violate their non-solicit, right? To go back and steal employees, which we were not doing. We were just a better employer. But either way, the litigation went to trial. And they were claiming violation of their non-solicit agreement and violation of their confidentiality provision that was in their IP agreement. The jury may or may not have found for our competitor on part of the claims. And what it came down to in the conversations with the jury afterwards was that we had hired 2 employees from a competitor. They started within a very close time frame. One employee sent another employee a confidential document from the competitor. Now, the employee that received it immediately deleted it, never used it, and it really wasn't even applicable to our business because our technology is different, and the document that was sent was specific to that company's technology. But all the jury saw was that a confidential document was sent from one former employee to another former employee. So prior to this litigation, what do we have now in our onboarding? A slide that reminds people to, if you have, look back at your contracts. Our talent acquisition team always asks, do you have a IP agreement? Do you have a non-compete? Do you have a non-solicitation agreement? But people sometimes don't remember. And you have to remind them to go back and look at their agreements and to honor those agreements. And also a reminder not to bring any documents, any confidential information from your former employer to Vanderlande. We don't want that information. We don't want you to use that information. And so now, again, prior to this litigation going to trial, but there's now a slide as part of our standard onboarding to remind people, because you don't want to get down the line and have, again, an email that was deleted that was no use to our company, but that was a factor in the jury, a negative jury outcome. And so that, and then also just being consistent with your policies in your handbook, right? People were all up in arms about the name and likeness clause. We already had a name and likeness clause in our employee handbook. I'm like, but nobody reads the employee handbook that I diligently work on every year, updating. And also, we already had a confidentiality provision in our employee handbook, right? But the confidentiality provision, which again was written before I joined, said that you had to keep information confidential for only 2 years. Of course, I changed that, expanded that. But making sure that if you do roll out an IP agreement, that whatever policies you already have are consistent with what you're rolling out in that agreement. So these were all the learning trials and tribulations that I went through. But I encourage you, if you don't have an IP agreement, that you should consider it and consider rolling it out to all employees. Thank you.
Yeah, I'm gonna stand. For me. Hi, I'm Chris Buntel. I'm suffering from jet lag, something horrible. So I live and work in Singapore, which is exactly 12 hours difference from Atlanta. So it's about 1 a.m. for me. So standing, I'll be much more alert. And trade secrets always kind of bothered me through my career. I did mostly patents and trademarks, a little bit of copyright. And the only time that trade secrets historically came up was when a client was deciding, do we patent this or not? And if the decision was no, for any of 100 different reasons, we would spend like 5 seconds saying, oh, then you'll keep it a trade secret. And that technology, that idea falls into this deep, dark hole of trade secrets and is never seen again. And then the next invention disclosure came along, you would do the same thing. And it always kind of bugged me that you have this great idea, something that we've invested a lot of time in evaluating, that basically gets tossed in the trash. So for 3/4 of my career, that always bugged me. And recently I helped co-found Tangibly, which is a company designed all around managing trade secrets. And I actually found an amazing quote from Admiral Rickover, who you may or may not be familiar with, but he's considered the father of the nuclear navy in the US. And back in 1981, he was giving a talk about the big shift in going from primarily a petroleum-based navy to a nuclear navy. And looking at this quote, I was amazed because it applies exactly to trade secrets like we're talking about today. So first off, good ideas are not adopted automatically. Trade secrets are getting a lot more attention, a lot more press, a lot more events like this one today, but you can't just turn a switch and instantly manage these assets. You do have to put in a lot of work. Continuous effort is required. Jim earlier mentioned just getting a snapshot of what's your trade secret portfolio today isn't enough, because next week or next month or next year, it's obsolete. Trade secrets evolve probably daily, maybe hourly, maybe minutely. It's always in flux, and you have to manage that over time. And then you have to sustain the effort to do this right. It can't be something that you get excited because you went to the Georgia State Bar, and then for a week it's on your radar, and then you get distracted and leave it. This really needs to be a continuous process. So, why now? For most of my career, again, it was all about patents for technology. And trade secrets in the last, really 2 to 5 years suddenly is getting a lot more attention and has gone from very low attention to a buzzword, and now to something that people are actually taking pretty seriously. So there's been a lot of change in the world, especially with COVID. So innovation moves faster and faster every year. It used to be that you'd have a technology and it might be commercially relevant for 20 years, 40 years, 100 years. Now it's more like it's relevant for 20 days. If you can get a new tech that's useful for a year, that's pretty amazing. And the patent system, for all the good it does, is really slow, right? I mean, it might take you 2 years, 3 years, 4 years to get a patent on your new technology. But guess what? Your product has moved so far, so fast, that patent that was expensive also is actually not even covering your commercial product. That's not really good. Things are much more international. Supply chains go across different countries. People working from home has dramatically increased the risk around trade secrets. It used to be you'd go to your company's building for your entire career and everything was locked up nice and tight. No longer the case. People work from home, they work from Starbucks. They might even be working multiple jobs at the same time. And people change jobs very quickly. Young people, especially, if they spend a year at a company, that's amazing. Wow, you were a long-term, employee of our company. It's not like the old days where you'd go to Toyota or Ford for your entire career. And also patents, people are a little bit tired of them. Patents, again, have been super expensive. You have to go country by country. it's a lot harder to get patents than it used to be. There's been this big kind of pendulum swing against things like business methods, against diagnostics, against super broad genetic technology patents. And people just feel like patents are no longer delivering the bang per buck that they used to. And all of that suddenly makes trade secrets much more important. And Jim made this point really early in the hour. Information is the big currency. Tangible buildings, machines, cars, ships, railroads, it's not where it's at. In terms of what the value of your company is, and especially if you're a small startup company, it's all about information. Your physical assets have marginal value. And there's been a lot of effort in the last few years to harmonize and broaden protection of information. So we talk a lot about DTSA here in the US, but there are similar ones around the world. So Europe has something similar, China, Japan. It's becoming a very international thing. And the differences between trade secret laws here and elsewhere, I mean, there are differences, don't get me wrong, but they're not that huge compared to patents where you could have something very patentable in one country and completely unpatentable in another. So there's been this real recognition and harmonization around trade secrets. And Jim mentioned this too, and the fact that I'm repeating a lot of what he's saying should be a hint that this stuff is really important. And if you think in terms of an iceberg, you have a little bit of ice on the top, but most everything is underneath the water. IP is kind of the same way. So on the top, you have the traditional forms of IP or the government recognized forms of IP in terms of having a registration, having a real process. So we all know patents, trademarks, and copyrights pretty well, and they do a certain job well. But there's a ton of useful, valuable information hiding underneath the water. Things like codes, like innovations, like manufacturing methods, data, all of this stuff is either really difficult to protect with patents, trademarks, and copyrights, or usually impossible to protect. You can't take your vendor list or your margin data or your COGS data or your customer relationships and get a patent on it. Like, it doesn't work. You can't patent those things, but they're incredibly valuable. If you went to a company or thought about your own company and said, how much would it take for me to give up my vendor relationships or to publish my pricing model or my margin data? Those things are incredibly, insanely valuable, but again, can't be protected by trademarks. You can't copyright it, and patent office will laugh you out of the door if you try to patent your customer list. It just doesn't work. There's also been this growth and awareness of what are all the different things that you can protect as confidential information or trade secrets. Again, I'm guilty of this as anyone for most of my career of just saying trade secrets equal technology. And really, trade secrets equals technology that I decide not to patent. And yes, that's a small piece of it. But this slide does a great job of listing out all the different things that could be valuable confidential information and could qualify as a trade secret. Things like quality control, things like packaging, sales forecasts, again, wildly valuable. Vendor relationships, competitive intelligence gets litigated all the time as a valuable trade secret, even though it's not technology. So I'd love all of us here to think a little bit more broadly about what trade secrets can cover, because it's a lot more than just technology. Now, in terms of a platform, one of the key titles of this talk today was, what do you do? So suppose you get super excited, you go back to the office this afternoon or tomorrow, what do I do? And most of the time, it's pretty hard because trade secrets haven't had the support and tools that other forms of IP historically had. So all of us have docketing systems, have websites, have service providers. There's all this great infrastructure around patents, around trademarks, around copyrights. But when you get to trade secrets, all that support isn't there, or at least not there yet. So at Tangibly, we came up with these 5 pillars of what a good management platform could have. So the first is, what is your trade secret? What is your asset that you're trying to protect? In the past, 5, 10, 15 years ago, you could be very vague about what your trade secret was, and the courts were okay with that. But like Jim said, there's been this push or evolution to being more and more specific and being more and more granular of what your trade secret is. So just hand waving and fuzzy clouds doesn't work anymore. The second one is, have you controlled access? So people, it's almost like a need to know basis. People who need access should have access. But if all 1,000 of your employees can go to a shared drive and view this trade secret, it's no longer restricted. And it also applies to people outside. So things like your contractors, your interns, your collaborators. So things like if you have a JV or a partnership or a research collaboration, it might make sense for them to have access to your trade secrets, but it should only be the trade secrets that they actually need access to. The third one actually goes to what Chantal was talking about, is contracts are super important. You need some kind of contractual basis to give you the protection for your trade secret. So if you just have no documentation or poor documentation, this prong is going to be very, very difficult. The fourth one is interesting. It's this idea of acknowledgement. So if you're on the defensive side from a trade secret litigation, it's very easy to say, well, I didn't know it was a trade secret. You never did anything to help me understand that this thing was valuable. And then finally is number 5, which kind of fits in that as well, is training. Again, we're repeating a lot of the same things today to tell you this is really, really important. If you have an employee that's gone through annual training, it's been tracked, it's been certified, just like a lot of the HR training, that goes a long way to avoiding problems in trade secrets. If you look at trade secret theft or trade secret misappropriation, a pretty big chunk of that is kind of naive or accidental theft. People thought, oh, I've been working on this for 5 years, it's mine. So I'm going to take it to my new company. Or they just thought, oh, it's normal for people when they move jobs to take this stuff with them. And they're not being a bad, evil person. They're not wearing a dark hat and being sneaky late at night. But still, they're doing something that's wrong. They just weren't trained for it. And in the cases where it actually is a person doing a bad thing, where they go out and start a competing business on their own, it's great for you to say, well, not only did you know it was a trade secret, but we provided training. You took all these classes. Every year you got recertified. We were serious about protecting our trade secrets, and we were serious about having a well-trained workforce that understood the difference between right and wrong. So that goes a long way. And again, providing training is not expensive. It's easy. It's not cheap. It's not free, but compared to the cost of litigation, it's a bargain. And today we've talked a lot about risks in terms of new people coming on board at your company, as well as old employees leaving. And both of those have a lot of risk involved. The other risk that people don't often think about is collaboration risk. And it's huge. So when you go into a partnership or a JV or some other external relationship, there will always be confidential information. Your information going to them, their information coming to you, and it's horribly managed. And in a lot of cases, when I talk to our customers and clients, it's not managed at all. Yeah, if you're lucky, there's an NDA. The NDA might say one sentence or one line about, oh, we're doing a JV between me and Neil. And that's it. Once that NDA gets signed, it's like fair game. Emails start flying, documents start flying. No one has any idea who's contacting that information and what's being done. So, information goes out, it comes back in. There's usually no tracking, which would be great to have. Who has access? Again, normally you send the information to your collaborator, and again, it goes into this big, deep, dark hole, and you immediately lose visibility. So it'd be great to have tracking for that. And then contamination risk is something that will bite you, but usually not for a year or 2 or 5 years. Is when you're talking to people and doing a collaboration, you might learn things and build on that without realizing it. And it's only when there's a new product or a publication or a patent application gets published or granted that you realize there's a big contamination problem. And platforms and apps, they don't make your life super easy, but definitely easier. So all of these things in terms of tracking your assets, tracking documents, tracking agreements, seeing who has access, and tracking the workflow when they come into your company as well as leave your company, it's a lot easier with an app. You can try to do it with Excel. We've heard of people trying to do it with Microsoft Word. It really is hard, and it probably doesn't work and doesn't give you all of those 5 pillars of good protection. And again, trade secret management is something that we're really excited about. And I think without deploying technology, either homegrown or through an outside provider, it's really, really hard. It's kind of like, what if I asked you to manage your patent and trademark portfolio with no docketing, right? It's laughable. Like no one would ever imagine doing that. But then you ask, well, what about your trade secret? It's like, oh, well, we don't have anything. And that's really the wrong answer if you're going to be serious. And doing all these things right will lower your chance of a theft because all the accidental people won't make accidents. And it will position you to be in as good a position as possible to go after the truly bad, evil thieves and ninjas that download 3,000 documents the night before they quit their job. So it's not perfect, but technology makes this much easier. And I always love the joke about fishing of, there's 3 sizes of fish. There's small, medium, and the one that got away. And we really need to collectively be very careful to make sure that your trade secrets don't get away. And this slide summarizes a lot of what all 3 of us have been talking about. So the first off is everyone has trade secrets. I ask people, how many do you have? And a lot of them say, well, we don't have any. We're making cement or we're making paper clips. But the reality is everyone has a lot of trade secrets, much more than they realize. Again, it's not just for technology. There are tons and tons of regulatory, of business trade secrets, of even legal trade secrets that people don't think about. And like on legal, like if I get an opinion of counsel, so I hire Mike to give me an evaluation of some risk, you could actually look at that and say, well, it actually meets the requirements for a trade secret, in addition to being attorney work product and attorney-client relationship and all that good stuff. But is it secret? Yes. I mean, an opinion from counsel I keep super secret, even within my company. Is it valuable? You know, yes, I paid him $50,000. Like, this was super expensive and super valuable. And have I taken reasonable steps to protect it? Hopefully, yes. Guess what? All those legal things that we never think of as being trade secrets qualify as trade secrets. So expand your thinking about what trade secrets can be. I mean, we have to be proactive. Again, the days of waiting for a theft to say, well, what have we been doing? It's too late. Yeah, it's exactly like fire insurance for your home. You know, you don't wait until your home is on fire to say, did I ever get fire insurance? Yeah, you're way too late. You have to be proactive. And also, we didn't touch on this so much, but when theft occurs, when you find out that something has gone wrong, don't wait. You know, contact your lawyers in-house or at a law firm and act very quickly to control the damage. And then finally, you know, statistically, about 70% of trade secret problems come from your own people. So it's different than patents where it's like big company versus big company. Trade secrets are kind of interesting where it's usually one person or a small team of people. And again, they're usually your own people. About 15% of the time, it comes from bad relationships, like a joint venture that started out happy and loving and sweet and profitable, but something went wrong. And then the final 15% is the true theft. So it's someone who hacks your computer, who breaks into your office at night dressed all in black, you know, the truly bad thieves. But you know, everyone worries about that 15%, and they don't really think so much about the 70%. But if you think about your risk logically, you know, train your own people, look at your own people, make sure your contracts with your own people are in good shape. And yes, you know, pay attention to the thieves and ninjas, but kind of balance where your risk is actually coming from. So that's the end. Do we have time for demo, or I know we're.
Looks like we have a little over 5 minutes.
Okay, and we also have questions and answers. So
we have about 8 minutes.
Okay, my suggestion is why don't we use that for Q&A? And then separately, if any of you are interested, I'll stick around as long as it takes to show you what Tangibly can do, just to give you an idea of how technology can help on this. But I'd love to hear your questions, and thanks all for being here. Yeah.
All right, so I again want to express my appreciation for Jim, for Chantel, and for Chris for outstanding presentations. And at this time, we would certainly love to entertain questions from the audience. We'll start from the very back. Lady in the back, yes, go ahead. Do we have any microphone? Is there a way to give her a microphone? If not, we can just, we can see.
Yeah. Yeah.
Okay.
You can ask your question, ma'am.
My understanding from several years ago is that New York State was the only state in the 50 that had not signed on to the state version of the Uniform Trade Secrets Act. If New York law is governing law for a contract, how important is trade secrets law? Or has New York signed something similar? I mean, I know now there's the federal defense secrets act. New York law. You guys should repeat that for Jim.
Yeah.
Sure.
Yeah, Jim, the question is talking about how New York, kind of asking about the status of New York trade secrets law, the fact that it has not adopted the Uniform Trade Secrets Act, and kind of any kind of differences between New York trade secrets law under its common law versus other states that have adopted the Uniform Trade Secrets Act. I'll let you
Yeah.
chime in, and I'm
Sure.
happy to address it as well.
Yeah, sure. New York follows the 1939 Restatement of Torts to define its common law and trade secrets. It's the last state that has not yet adopted the Uniform Trade Secrets Act. And so it is substantially different in the sense that you're required to show that the information is in continuous use in the business. If you have research underway, but it hasn't been implemented, if you have information that hasn't yet found its way into an actual product, then it's very difficult to protect that. And so I used to tell people, well, now that we have the Defend Trade Secrets Act, if you're going to file in New York, if you have to file in New York, go to federal court if possible. But now for plaintiffs, we have a big problem in New York around damages law because I forget EJ, I forget the last name of the case. The top court in New York said that damages based on avoided costs, which is a major part of recovery for plaintiffs, is simply not available under New York law. So yes, go to New York, but then a couple of months ago, we got a decision from the Second Circuit Court of Appeals that under the DTSA, very, very limited availability of avoided cost damages. So right now, I'd say to people, stay out of New York entirely if you can.
By the way, Jim just came out with an article, a very well thought out article about that Second Circuit decision, an IP watchdog for those of you who get that feed.
Yeah, and the name I couldn't remember is EJ Brooks is the name of the case that came out, I think, in 2020 from the Court of Appeal, which is the highest court in New York.
Did you have a question up here?
Yes. Kind of two questions. One, if you do an NDA at the beginning of a relationship, do you let that stand, or do you incorporate that maybe in a final document between the parties? And second, if there are any drafting recommendations, a lot of times trade secrets from a contracting standpoint is just, one of the parts of confidentiality. But would there be other provisions that you think could be more robust or that should be paid attention to more for particular drafting techniques? Someone who drafts contracts.
Jim, did you hear that one as well?
Yeah, I heard it, and my response to that one is always make the NDA a separate agreement to begin with. You need to address those issues. Don't just fold it into the overall discussions on the agreement itself. You will, when you get the transactional agreement, you'll certainly be making reference to the NDA, but don't leave it for that. And as far as—
I'm sorry, just to clarify, my question was, let the NDA stand even when you do the final document.
Oh, yes. Yeah.
Okay.
Yes, you
Not
do.
just fold
Because
it into the final.
that defines the responsibilities and the nature of confidentiality. And so you want that to be a lasting document. But when it comes to the issues, one of the most important ones is how much risk do you want to take, for example, with time limits. It's common these days to see 3 or 5 year time limits on these things, which represent an important concern for the recipient of information that doesn't want to be shouldered with the administrative burden of trying to keep track of the things they're supposed to protect and who has access to it, et cetera. But at the same time, the company on the other side that's providing the information may have secrets that have indefinite life to them, and if you put a time limit in the agreement, then you have basically provided a full license to the information once that time has expired. So that's pretty critical. Another one is, how do you deal with verbal disclosures and so on?
All right, thank you, Jim. We've got time for one more question. The gentleman in back.
Hey, this is for Chris. Does your software do anything about balance sheet valuation of trade secrets, which I've yet to find in a case where anybody has done any kind of cost valuation and put it under intangible assets on their balance sheet?
Sure. It's a great question. So far, we have not touched on valuation of trade secrets. Not because it's difficult, but we're not there yet. But how to value intangible assets, especially when there's no revenue attached to it, it is pretty difficult, and it's definitely an art form. But tangibly, so far, we haven't touched on that.
Yeah, and look at the guys like Aon that are engaged in using trade secret assets as backup for insurance and for financing. They have it's an art form more than a science, but they have a program for identifying and valuing those assets so that money can be loaned against them, and same for insurance.
Yeah, like the Singapore government has a program where you can borrow money from banks that are backed up by the government, but coming up with a valuation for the IP is pretty difficult, especially if you can't do like an NPV or any kind of normal discount rates. If you're a new company or a small startup without any commercial traction, it's very, very difficult.
All right. So if you've got any other questions, please come up and see us. And then Chris, for those who want to stick around, Chris can do his demo of the Tangibly platform. But again, at this time, we'll go ahead and end it here. And again, thank you all for attending this CLE session.